Today, a long overdue recommendation for a spent conviction scheme to be introduced into Victoria. And what that means is that historical convictions that live with people, that stigmatise people, that prevent people from receiving employment, sometimes even accommodation, hopefully can be put in their past so people can move on after they have rehabilitated themselves, have been living without crime. This recommendation hopefully will be adopted by the government, and we will see people with irrelevant and historical convictions have those convictions not disclosed when they're seeking employment and when they're trying to get on with their lives. We heard from people from all over the state. Everyone agrees that this change must happen. Victoria is the only state in Australia that does not have a controlled disclosure or spent conviction process.
What have you recommended?
So we have made one large recommendation that there be a framework for controlled disclosure established in Victoria. And that would mean that anyone who had been convicted of a crime and sentenced of that crime and possibly had received a custodial sentence of up to around 2.5 years, after a crime-free period, that information would not be disclosed to third parties. Of course, that information will always be available for police, it will always be available for courts, it will always be available around working with children. And certain crimes will never, ever, will always be disclosed, and that would be sex offences and serious violent offences. But this recognises that people make mistakes, and we want people to be able to get on with their lives, that mistake that they're made does not live with them forever. People deserve a second chance, and I think this legislation does that, and the recommendation does that.
So, after what sort of period do you think? How long would someone have to go without committing further crimes, I guess?
The crime-free period, we didn't pinpoint an exact crime-free period. We have recommended that the government consider this and that it sit somewhere between 5 and 10 years for adults and 3 and 5 years for juveniles. There is no great evidence on what the perfect time is. What we know is that the greatest protector to reoffending is employment. And what we know, the greatest barrier to employment from offenders is that criminal record. So by allowing that record to not be disclosed, we will help people get into employment and we will prevent them from reoffending.
How does this scheme compare to others?
The scheme that we have recommended really sits within all of the schemes in Australia. And the first scheme was developed in 1986, and now we're in 2019 developing one for Victoria. And we have taken a very measured approach, and we believe that in actual fact the government needs to make that decision around whether it would be 5 years or 10 years. We think it should be automatic, that after a certain crime-free period has passed, then the restricted disclosure of that information should come into play. We also think there will be circumstances that sit outside that situation, and that those people may be able to apply to the court to have a restricted disclosure placed on their convictions for good reason. We're seeing changes in jurisdictions like the UK, which is saying if someone has been imprisoned for anywhere up to 4 years, that a restricted disclosure process could be effective for those people. In WA, there is, apart from life imprisonment, there is no restriction on who could apply to have their convictions restricted from disclosure. I think we heard some remarkable stories about how something that happened to someone in their long distance past, some mistake that they made as a young person, has continued to live with them all their lives. And that would be as simple as stealing a piece of wood when they were a teenager, through to other crimes that were committed. But what it has prevented people from doing, sometimes it prevents people from applying for jobs altogether. But what we saw in the Aboriginal community in particular was the lasting effects on even kinship programs. So not being able to look after your niece and nephew because of a crime you committed 30 years ago. So it was, we heard some very moving stories, and we heard some very poignant stories, and I'm just so grateful that so many people were willing to tell us their stories, to put their faith in the committee process, that we would respect that. And as a result of those stories, we have, I think, presented a very good recommendation that will bring Victoria into the 21st century and fully recognises the implication of historical convictions, and particularly irrelevant ones, on disadvantaged groups, and in particular our Aboriginal community. We had a minority report that was overwhelming. I think everyone on the committee agreed that there should be a spent conviction process, and there should be spent conviction legislation. Where you draw the line on the crime-free periods, where you draw the line on the level of offending, was where we didn't come to agreement. So it was on the details. Overall, we all agreed something needs to be done, and something needs to be done now. When I tabled the bill on spent convictions earlier this year, the government certainly indicated that they supported a spent conviction scheme. In fact, it was the government that referred this reference to the committee and asked the committee to consider what a spent conviction scheme would look like in Victoria. So I am hopeful that they will act swiftly on this, and we would see legislation from the government later this year. Should we bring Jackie?
Yeah, very quickly.
Great.